all the different laws that we need to worry about using social media, and because we're a social media marketing company, we thought it would be fitting. So Tiffany will get started. She has some housekeeping to go with first.
Yes, I do. Okay. So like I said, thank you everyone for coming tonight, and if you're watching from Facebook Live, thank you for checking in. So we are recording this on Facebook Live. We also have a video recorder in the back. So once again, just a filming notice, if anyone does not want the back of their heads to be on camera, let us know and we'll try to push it the other way. All right, so I would like to thank AIM Social Media Marketing for this collaboration, and also we have Derek from Delirium Media who is filming the event, which would not be happening without their help, I can tell you that much. So this informational seminar, I just want to kind of precursor the whole event by saying that it is just that, it is for information only. Please do not take anything I say tonight to be legal advice specific to your situation. There's a lot of details, and in doing my research for tonight, it's just absolutely massive, and the rules can just keep going and going and going the further you look into it. So really your situation is going to be very specific. So talk to me afterwards, send me an email. We can look into it more in depth, because this is going to be just a general, overall sense meant to inform you and make you laugh and entertain you. Okay, so who here, in going along with that thought, who here does have a legal team or someone licensed by the Law Society that they can ask questions? Okay, a couple of you, perfect, good. Because as we go throughout tonight, you're gonna see that it's really important just to have that person, even if it's your second cousin's wife's brother. Very important just to have somebody that you can ask a quick question, because you could land yourself in real hot water, as we will see later on tonight. Okay. All right, so to get started, who am I and why am I talking? So as Nicole said, my name is Tiffany Bauer. I'm the founder and the licensed paralegal of Bauer Legal. But what the heck is a licensed paralegal, and why isn't there a lawyer up here talking to you? Well, in Ontario, licensed paralegals are very special. We have our own license, and we can represent you ourselves in lawsuits. You don't need a lawyer. So for the subject matter tonight of social media, that is within our jurisdiction. We can represent you in the small claims court with a monetary amount of up to $25,000. So for the average social media company, that should suffice, unless you're doing something majorly corporate. But it's always good to just to ask, because if you can seek help from a licensed paralegal, we typically charge less than a lawyer for the work that we do, so you're going to save a little bit of money, and it never hurts to ask, right? If it is something that is outside our scope of practice, we will tell you, and we'll even probably refer a lawyer to your specific situation, so it's a win-win. So just to reiterate, lawyers can practice in all areas of the law. Licensed paralegals can practice in a limited scope of practice, but we still operate under our own authority. Okay, so tonight, in researching social media and the law, there's a lot of different areas that I could have gone into, but the first half of the presentation, I'm just going to be gearing it towards the average general user. Then we're going to take a break, get some more drinks and snacks, and the last half is going to be geared towards more the social media marketing company. A little bit more in depth, might be a little bit dry, but I promise I will try to make it as entertaining as possible, because some of these rules you just have to grin and bear it and get through it, but we will. So for this presentation, this is going to apply to anything you put online. We're going to be talking about legal principles in a general sense. We're going to be talking about Facebook, Pinterest, anything you put online. Okay. This is a cartoon here, which may or may not make sense, but I'm going to explain what the duty of care is and why we're talking about it. So we all have a duty of care to one another. That being said, the extent of duty will vary greatly depending on the relationship. For example, a doctor or a nurse would have a much higher standard of care because the risk is greater. A person walking down the street actually owes a duty of care to the person who's also coming down the street from the other way. However, his duty is much less. He owes the duty, for example, of not setting this guy up to trip on something or punching him in the face, but basically not doing anything to harm the other person. So this can be related to the internet because you have a duty of care to other people out on the wild web. I like to explain this in terms of if we think of words as weapons. So if I go online and I'm posting horrible, nasty things about a person, if we think about it as a weapon, that would be an assault. That would be a criminal charge. That's not okay in our society. So in the same sense, it's not okay to go online and just post hateful things whenever you want. That's why we have laws in regards to hate speech. Now, you might be thinking to yourself, okay, that sounds good, but what about my right to free speech? You do have the right to freedom of expression. However, the catch here to that is that your right to freedom of expression cannot infringe, bless you, cannot infringe someone else's rights to, for example, be free from discrimination. So you can almost say we owe a duty of civility when posting online, which is a very low threshold, but it is still there. Also, I do want to say, throughout the course of tonight, if you have any questions or if what I say is not making any sense, feel free to raise your hand. This is just going to be a very informal talk, so go ahead and ask away. Okay, the next one is also going to be a cartoon. I don't know if anyone's, you probably heard of tort law, which we'll get into next. Okay, so this is the cartoon I like to use whenever I'm talking about torts. And also these jokes are merely cartoons. I am not the author. They're merely for entertainment purposes, and the author usually has their name signed on the work. A tort, I'm getting into that right now. Yeah. So, a tort is a contract law principle, which basically means wrongdoing. So I think that kind of explains the joke a little bit better. But it relates back to your duty of care. So if you were to intentionally or unintentionally really cause a person harm online, so really cause that person emotional distress from the things that you keep posting online, this would be called a tort because it's a wrongdoing. And this legal principle is based out of contract law. And it's because you have breached your duty of care, which is basically civility. Okay.
How would you use it in a sentence? Like you say...
A tort?
Yeah.
Well, so this joke here, he's purposefully going up behind her and just pulling the chair out so she falls over and gets hurt.
How would you use the word tort?
A tort is a wrongdoing.
Yeah.
Yeah. So
you torted her? A verb or a noun or what? I mean, how do you use it in a sentence?
I know, that's suing based off tort. Well, the funny thing is because if you were to look up a tort lawsuit, they would only use the words very frequently. It's not like when you're presenting your case in court, they would say the word tort because it's just generally understood that a tort is a wrongdoing.
Okay.
So they have, so if you want to learn about personal injury lawsuits, you would look up tort law. Yes, but you wouldn't be in court saying this is a tort, this is, so it's one of those things, yeah. All right, so now I'd like to tell you a story. I don't know if you're going to find it so crazy, but for me, myself, the reason why I find it so crazy is because as I was driving here today, I drove by a tire shop, and I noticed there was a guy standing outside the tire shop, and obviously his car had a flat tire, and he's in there, and his car is in the shop, and he's probably going to have to pay a little bit of money to get new tires on his car. And I'm thinking to myself, oh, that sucks. Like, I've been in that position where you have unexpected, a fine that you have to pay, or some unexpected expense comes up, and you're not prepared for it, and it's just horrible, awful. Well, in this case here, this man had a $15,000 unexpected expense. So I would deem that a little bit crazy. So what happened was, I don't know if you guys remember, but every time you receive an email, I know it was on the old Hotmail, but you could report it as spam. I don't know what happened to that. Maybe it's just me. I'm technologically impaired. You can tell by my slides. But they have a spam reporting center. So all those emails that you get to you and you say, what the heck did this come from? I didn't want this. This is spam. You can report that. So this center started receiving numerous complaints about email advertisements, all stemming from the same website. So they conducted a full investigation and they found that all the links would redirect them to the same website, and that all the links listed the same domain protection service to block their registration information, which the investigator took to mean that there was only one single sender of all these spam emails, because it's all coming from the same source, essentially. So looking into it more, they found that they were all coming from the same IP address, which was registered to a home. They got a hold of Bell. This home has 2 phone numbers listed for it. Both the phone numbers belong to the same person, a Mr. Rapinos. So Mr. Rapinos was served with a notice of violation, and this is a long one, from the Radio, Television, and Telecommunications Commission. Okay. And that would also be your governing body as well for some of the things that the social media marketing companies are doing. So he received a notice of violation with a fine of $15,000. So here's where it gets interesting though. Mr. Rapinos' defense is that it was not him that sent the emails and that he's a victim of identity theft. And this is where my bleeding heart goes out to him. He went on to submit that he was a landlord that frequently had boarders in his home. His Wi-Fi he had left unsecured. There's no password. He submits that a previous tenant had set up the website using his Wi-Fi from his home computer, because he just had one for the whole house, and used his name and information because they knew they were doing something malicious. He also submitted that because they do not verify identity to set up the domain name or the website, there was no way they could prove it was him. Well, upon further analysis, the commission decided otherwise. They kept the fine of $15,000, and this was due to the fact that Mr. Rapinos offered really no evidence to back up his claim, and it just wasn't probable enough. Because for their standards, it just has to be, it's a balance of probabilities. So this man is thinking it's beyond a reasonable doubt, which is a criminal standard of fault. He's saying, well, you can't specifically prove it was me, therefore you can't find me. But that's not true, because in this board, it's based on a balance of probabilities. So is it more probable that this makes sense that you sent those, or less? And they decided, no, this sounds like it was you. So the reason why I think this one is a little bit crazy is because I believe his story. I think that his defense is doable. I think it very well could have happened to him. Is it probable? No. But it very well could have happened. Stranger things have happened. But on the other hand, though, if it was him, he was probably just a guy that just didn't know what he was doing was against the law. He didn't know he could get into trouble. Otherwise, he wouldn't have been doing this, right? So essentially, he was paid $15,000 fine just for not knowing what the law is. So I think that's a little bit crazy, and we're going to be getting more into the promotional emails in the second half. Okay, right now I want to talk about a big one. Defamation, also known as slander, also known as libel, also known as defamation of character. What is it? Essentially, it's what you say about someone else. It can also be what you say about their brand or their company. It can also be what you say about a company's employees. So it loosely means that you're talking bad about someone online and you're destroying their character. However, there's a catch to this one in that you must have a character to defame. And what we mean by that is that the average person is not going to be able to sue for defamation of character because if they don't have a prominent standing in their community, it's not really going to matter so much that people are talking poorly about them. They're not going to suffer damages in the public eye. A politician or a doctor, on the other hand, would be able to because their reputation is very important in the community. So if someone goes online, they're saying crazy things that are not true, then they most certainly have a case for defamation.
Just saying as you're talking, because I don't know it personally, but you read about, especially kids, teenagers that, they can get hurt really badly on social media, it seems to me. They're not doctors or lawyers, but you hear suicide and stuff like that people really...
Yes. Yes, so that would be a tort lawsuit because that person's suffering emotional damages. So that is definitely a wrongdoing. You could potentially sue for wrongful death if the teenager were to take their own life. Well, wrongful death lawsuits have to happen after the death, but you could sue for emotional damages before that, yes. But no, that's certainly worth looking into. So if you're a well-known business person, so you're somewhere along the middle there, you're just trying to start your company, you may have a shot at a defamation lawsuit. But if your company is brand new, you're just starting out, it's a lot harder to estimate how successful your company is going to be in the future, and that's where your damages are going to stem from. So if you're already hugely successful and somebody posts horrible things about you online that are not true, and you start to see your sales plummet, the brand plummets, the stocks plummet, those are your damages. It's the difference of the money that you would have had if those comments had not appeared. I was just looking the other night, there was an Australian actress. Her name is Rebel Wilson. She just won, this was supposed to be like, you saw this? Nicole's laughing. Did I say her name wrong?
No.
Okay, why are you laughing?
Just go ahead.
Okay, all right. Yo, I know why you're laughing. Okay, you know why she's laughing? It's because this actress sued a media company. The name of the media company just so happened to be Bauer Media. No relation. But I'm mentioning it because she won a hugely monumental amount of money. She won $3.6 million US just on defamation alone. So this Bauer Media magazine wrote some horrible things about her in their magazine, and they published it. And she argued that had it not been for this magazine defaming her in that way, she would have been able to book more jobs. So that's the money that she lost out working as an actress. Okay, there's another case though that occurred, and it all happened on Twitter. And I wanted to share this with you because it does briefly roll into employment law. But it shows you though just how careful we have to be with what we post online. And I hope this is going to work for me. Nope. Okay, well that's okay. We don't need it. All right, so the TTC, I believe that's the Toronto Transit Commission, was recently criticized by a provincial arbitrator in a labor ruling. So when you're working for the Transit Commission and you have a dispute about your workplace, what they did is they went through an arbitrator instead of taking it to court. But anyway, so this guy ruled in regards to a Twitter account that the company had set up to deal with customer complaints. So basically they created a Twitter account so customers could complain and they could respond accordingly, which makes sense. You know, it's a lot faster. Just go on Twitter and do that. But unfortunately what happened is the public was not so civil because they were very upset. So they started bashing, insulting, and degrading the employees themselves of the TTC. They went so far as to snap photos of the drivers and the operators and then post it online and name them as the scum of the TTC. The general public was downright abusive, and a labor claim was brought forward because these employees are supposed to be working in an environment that's free from harassment. Their employer is supposed to provide that. So when people became outrageous and aggressive online, the TTC merely responded with a link to follow to lodge a formal complaint. So the arbitrator ruled that the TTC did not do enough to protect its employees because, of course, you can't stop the general public from swearing or insulting, but you can do things to not encourage that type of behavior. And the arbitrator thought that by merely just giving them a link to follow, it was almost encouraging that type of behavior. So they were ordered to immediately address certain users and warn them that the language was not appropriate and that if they did not conduct themselves in a better manner, they would be blocked from the account. The arbitrator ruled that although you can't stop this behavior altogether, you can show your employees that you have their back and you are trying to protect them. When this was reported in an article from the Toronto Star, they had interviewed a man that had been working for the transit authority. He said it had a tremendous effect on his health. So they noted that in their findings, but unfortunately by the time the article actually went to print, he had passed away. So whether or not that's related is, they didn't say whether it was related, but that's still a horrible thing because it very well could have been related. So this is something to take very seriously, especially if you own a social media marketing company yourself, because you guys are the ones answering to the online complaints and the online activity. So you'd have to be aware of the employment law obligations to protect the employees from harassment in that manner. Okay. This next slide, okay, I'm not connected to the internet, but I think we're going to be okay. The links that I was going to go to, they just had a couple more jokes in them, but we can do without it. It's okay. I know what they were, I can tell you. So right now, I don't know if you can see it really well, but we're going to talk about something a little bit lighter now. We're going to talk about self-incrimination on social media because people can do things to really, really, really incriminate themselves, and it's really, really funny. So we're just going to take a look. Okay, so when you post something online, everyone can see it, obviously. And depending on where you post it, it could be there forever. You may not have a chance to delete it, or someone could take a picture of it before you have the chance to delete it. So you always have to think twice. But this especially comes into play when you have pending litigation. There are lawsuits where a plaintiff has posted her outrage online, his or her outrage online, and then the post goes viral and the general public all jumps on board with her. This is horrible, how could this happen? Are you okay? Yada yada. And then she starts talking about her symptoms and what she's doing afterwards. And this is all information we don't necessarily want the insurance company to know, okay? So when you have pending litigation, keep all that stuff offline, please. It will help your lawsuit immensely because it keeps the other side with only the information we want them to know, okay? So the lawsuit or even just a claim with the insurance company. If the insurance company is being good to you, you put in a claim, still don't post things about it online. If your claim is for a broken foot, probably best not to post photos of you water skiing on vacation, which happens so often. So often. I went to a tort law lecture in Toronto, and he was an insurance claims adjuster of over 50 years, and he just had the craziest story. He said this one guy had put in a claim for a broken finger, but he kept posting photos of him at a bar drinking mugs of beer like this. And they're like, well, if you're well enough to go out and you can handle, holding on to a great big chug of beer, they said, we really don't think your finger's that damaged that much, right? Obviously you can still use it. So insurance claims are denied because of what people post online. Okay, so I wanted to show you also from the criminal perspective of how some people incriminate themselves. This one here, and of course this is just a news article that I took offline, so all the information's on there so as to not steal any copyright issues or anything. And it says, criminals caught on Facebook. Huntington Beach riot suspect, Louis blah blah blah, arrested after liking his own photo on the police Facebook page. That was a good one. I like that one. If you click the link, the first picture that shows up is this guy. He's kneeling in front of a police car. He's siphoning gas. He's going like this for the picture, and he literally posts it online. Yeah. So, moving on. Okay, so more importantly than not landing yourself in jail is your reputation. When you post things online, they're there forever. Some people, there are people who have lost the right to claim for a lawsuit. So if you have the law firms will go back through your social media account, and they will go back years, and they will find anything in your online account or anything that you posted to show that, no, you don't have a right to the claim, and this is why. Because of something you posted online, that would prove to the contrary. If you have I don't want to use this as a specific example, but I hate to go back to the wrongful death lawsuit. But in order to have a claim for a wrongful death lawsuit, you have to prove there was a relationship. So if you had a very rocky relationship with the person and you're constantly bashing them online, that's going to prohibit your claim down the line. So I don't mean to use that one as an example, but it's the only one that comes to mind right now. So also, people looking for jobs, obviously your future employer is going to do a Google search on you, and probably a much more invasive search if they're more technologically advanced. A lot of professional regulatory bodies have rules and regulations in regards to professional conduct and a code of ethics. This applies to what you put online. That's all demonstrated by what you post and talk about, which shows up online. You can be fired for posting inappropriate things, especially when you're in a position that requires morals and ethics, even if you're not in that position right now. You don't know what your career is going to be in the future, so it's just better, just play it safe, just be civil. Have your grandma on your Facebook account, and if you can't post it in front of your grandma, it shouldn't be going online. No. So the rule is, dance like no one's watching, but post like it may one day be read aloud in a deposition. That's not my joke. I stole that. Okay, from online. Okay, so this was the first half. We're going to take a break right now. When we do come back, we're going to go into more of the rules and regulations and things to watch out for in terms if you do have a social media marketing company, or in terms of if you're doing the social media marketing for your own company. So things like contests, things like promotional emails. We'll get more into the nitty-gritty copyright laws, things like that. So grab a drink, grab some snacks, hit the washrooms, and we'll be right back in 10. Okay, there's one last cartoon before we get into copyright laws. Well, if you followed me on Twitter, you'd know your diagnosis. So obviously, we don't want to be posting highly confidential information online as well. Just a quick note on that one. Oh, there we go. Okay, let's get into copyright laws, because what you post on your online accounts, the artistic expression of your work, is going to be covered under copyright. This is also a term that gets thrown around a lot. So a copyright means just that, the right to copy. Very cool. It's not to be confused with patents or trademarks, which protect different things. Copyright laws protect the following: literary works, paintings, photographs, drawings, films, music, choreography, sculptures, and your social media posts that you have created and designed specifically for your company. Why are you giving me the look, John?
No, I'm just thinking about literary works, but if
Mm-hmm.
you cite the author, you're not.
Oh, don't worry. We're getting into more specifics. Yeah, don't worry.
My look was just.
Don't worry, I'll keep going. I'll keep going.
Am I under?
No. So, no. So copyright laws do not protect someone's ideas, but they protect the artistic expression of those ideas. So your work as social media marketing companies would fall into this category. Now, if you have an idea for an invention, that would be a patent. A brand or a slogan would be protected by a trademark. Now, the good news is that unlike a patent or a trademark, which you have to apply for, the copyright is inherent when you create the work. So you don't have to apply for the copyright, it's yours immediately. If you would like, and it's always a good idea if your work is going online, to mark it with a copyright symbol and the information of who the copyright belongs to. So if you'll notice, oh, you can't notice. Oh, well, on my slides, I don't know why it's not showing up there, but on my slides I did copyright at the very bottom. I couldn't get it on my keyboard. It is a C, but there's like a circle. Yeah, so
Okay.
unfortunately, I tried to show you, but it's not working for me. So I just did parenthesis, C, parenthesis, 2017, comma, my name. Just to show that these are my slides. These are the artistic expression of my ideas. Not the jokes within them, which have been signed by the author of those jokes.
Maybe it's something where you can post the website of where you got
Yes.
that picture from.
Exactly.
By applying it onto the photo and making it an active link on the photo, which I found fascinating because I want to learn how to do that because
That does sound very cool.
it is.
The only thing I'd be worried about that is if the image is kind of hiding the link. You want to stay, we'll get more into the source citations, but you would want to be very, very clear that there is a link to the author, and so if it's in the actual picture, I would just be worried that the picture is obscuring the link, so that if you look at it quickly, you wouldn't be able to see the link, but if that's not an issue, then that sounds really cool. So, again, this sounds wonderful if we're talking about protecting our own work, but that also means we must be very careful not to infringe someone else's copyright. This usually happens when you take something you found online and use it for your own personal gain, and of course we're talking about monetary gain. So if you take a joke off online and you post it to your Facebook account to show with others, which everyone does, they re-forward jokes and things like that, you're not making any money off of it, you're not claiming the work as your own, it has the signature of the person who did the joke, you're fine. Because in Canada, we have what is called the fair dealing. Not to be confused with the American version, which is fair use, but we do have a Fair Dealing Act, which goes into a lot of detail, but it's what they would use in a copyright lawsuit, and it would protect things for the use of private study, criticism, to review, to exact an opinion, etc. So John, I think this would be more in line with your work, because John is a writer. One of the things John does is he's a writer. So if you were to take a paragraph of someone else's book, post it on your social media account, and say, you know what, I really disagree with this author, and this is why. That's perfectly acceptable. Because under the Fair Dealing Act, this person, it's still being recognized as his work. You're not taking it and using it as your own work. You're not saying this was my writing. You're not using it to make money off of that. So that's perfectly acceptable. So again, just source where you get the information from, and don't use it in the course of making money, because that'll lead to damages. Yes?
With fair dealing, the difference, is there a difference? Like with fair use, I know in the States, they allow for like comedic and parody. Is fair dealing, Is that,
That's where we differ. We differ greatly from the fair use. So I know a criticism.
a comedic commentary could fall under criticism, could it?
I think you have an argument for that,
Yeah,
but it gets so nitty gritty.
nuances.
Yeah, it gets so nitty. So I think you definitely have an argument. But again, just cite the source,
Yeah.
right? And then you avoid that problem.
Sure.
Yeah. Oh. Okay, so this is an example from my own Facebook page. This was a post that I had put together. I took a photo, which you can't see, but where the photo is from is on the photo itself. And then I wrote at the top, so you knew you were legally responsible for Fluffy, but did you know there's an act for that? The Dog Owners Liability Act. What's the worst kind of trouble your pup has gotten into? Stopping short of admitting liability on this page, of course. So this was a post that I had done on my page, and this lady took my post, she shared it onto her page, and she wrote a little blur about it. Attention all dog owners, my poor dog was attacked, this and that, and she's using my work to back up her claim that this was wrong, what happened to her dog. Okay, so I had to do this in two parts here because I couldn't get the whole thing on the one slide. But at the bottom there, you can still see it's from Bauer Legal, and it has the rest of my post. So this is perfectly acceptable. Because I would have no problem with this. I'm very happy she did this because she's taking my work and she's using it to prove her point. And I'm still getting the credit for it, and that's great promotion for me. So that's wonderful. So give credit. So to reiterate, remember we were talking about those legal professionals, those people you can go to ask. Just ask them if you're not sure. Give credit by stating where the source came from, and mark your own work for extra protection. Just when in doubt, source where you received it. I have heard that stealing photographs off of Google is a big issue. That's not going to be okay, especially if you are running your own social media marketing company, because you are literally being paid to come up with the creative advertisements for another company. So you're making money off of this. So you cannot just steal images off of Google and use them in the creation of what you get money for. So you have to come up with your own work. There are sites which, Nicole, can you name one of the sites that you get?
Stock photos?
Stock photos. So there are sites like Stock Photos. You can get those photos from there and use those photos, and that's not going to infringe copyright law. Did you want to add something, Nicole?
Pexels is a really
Pexels,
great
yeah.
photo site.
Yeah.
What is it?
Pexels, it's P-E-X-E-L-S.
Mm-hmm. Okay, this here I wanted to show you. Actually, I just found this today. So I was looking at BizX magazine. They always have their top choice awards. And I just stumbled across this, and I was looking at their short rules, which is the rules that they include with their advertising. So I've kind of zoomed in on the portion that I wanted to note, and it says, note, any use of the trademarked Top Choice Award logo is not permitted. So right here, they're clearly letting you know that their logo has been trademarked and you're not allowed to use it. That's wonderful. Now, that being said though, if you do go and use their logo, you're gonna run into trouble. So it is always good to read the rules thoroughly, but whoever did their social media did this perfectly because they included that in the rules. So it makes it very clear, you can't use their logo. Take water, and then we're going to get into advertising law basics. Because when you're posting online for your companies, it's really just advertising. Okay. So
That's funny, if they're running a competition for all awards and someone's granted that award, wouldn't they be able to use that award logo to say they won the award?
So those rules were to be used in the promotion of the contest. So because what happens is you have to apply, and if you're eligible, they accept you as an applicant, and then people have to nominate you. So you have to find ways of getting people to nominate you. And they're saying there that you can't use the logo, yeah, for that purpose. Now when it comes to the long rules of the contest, and we'll get into the difference of short and long rules for contests in the next slide. But when you get into the long rules, that's where you're going to get into the winner release and the rules in regards to actually winning the competition, which maybe you are able to use the logo then. But this is for promotion and trying to get the nominations. Yeah. Okay, so the first one, the Competition Act. At a federal level, this act regulates advertising and marketing and contains both criminal and civil provisions. It covers things like performance claims, false testimonials, bait and switch advertised prices, promotional contests, telemarketing, and double ticketing. So again, it's always important to seek legal advice because the fines for individuals go up to $750,000 and $10 million for corporations for things like misleading advertising. So on a provincial level, we have and again, like I said, this is just going to be a very general overview. These are the acts that are going to apply to you in your course of work. But again, if you're concerned about anything or if you need more research, that's something we'll have to get into at another time because it's very exhaustive. So on a provincial...
You're going to talk about the competition first.
Oh.
Are you going to consumer protection legislation?
Yes. Yeah. Yeah, so on a provincial level, we have the Consumer Protection Act, and this one regulates kind of the same thing, but on the provincial level. So regulates things like misleading advertising and marketing, but it governs specific industries. So for example, direct sales, gift cards, auto repairs, and fitness memberships. So certain industries, misleading advertising, regulated on the provincial level. So, in the case we spoke of earlier, where the man was fined for the email marketing campaign, he was in contravention of Canada's anti-spam law. That is also very extensive, and we're going to touch on that in the next slide. Contests, promotional contests, have various aspects from different legislations. So again, we're going to have more details on the next slide. I do want to touch on the promotional emails and the contests, because I think those are biggest in running a business on social media. Industry codes. So there may be additional laws and regulations that apply for a certain industry. For example, if you're a social media marketing company and your client is a payday loan company, that's huge. They are highly regulated, and you're really going to need to seek a legal professional because that opens up a whole new door of things that can apply. It's very regulated. Social media rules are also something to look out for. So every platform is going to have their own set of rules, and quite frankly, that again is very exhaustive. So just understand that if you're going to do your work on a certain social media platform, you should take the time to read over their rules just to make sure. For the average user, you should also note that for things like when you post your personal photos on Facebook, Facebook actually now owns the rights to use your photos. So when I was younger, I would post all my family photos on Facebook, and then when I found that out, I freaked out and I tried to delete all the photos, but there's just too many. It goes back too many years, so I just gave up. But just, know that when you're posting online to Facebook, essentially, you're giving them your photo. So, something to note. Okay. Promotional emails and Canada's anti-spam legislation. So, promotional email marketing campaigns is where you have a lot of emails that you send out, like a monthly newsletter, informing people of what's new with your business, current specials, promotions, things of that nature. And that falls under Canada's anti-spam law. Again, we're going to see a difference from the States. Here in Canada, we have an opt-in system where the person must first give consent to opt into the emails. Whereas in the States, they can send you anything they want as long as there's a button to unsubscribe or to opt out. So here we see our system is going to take a lot longer to acquire your emailing list, but it's going to be a lot more, it's going to be higher quality because you're going to get less people opting out. What you never want to do is buy your list. That's very dangerous because you don't know if consent has been given for them to be on that list. So you never want to buy your list. You're really just throwing money down the drain. Don't do that. So play it safe and just promote, promote, promote.
So even if you're a business and you're sending out emails to your clients, you have to, if it's a programmed email to them, like you're promoting something on it and it's going to.
Yeah, so if you're.
You still have to get their permission to send to them, or?
Unless you already have it written down somewhere. So what we're talking about here is like a monthly newsletter.
Right.
So for me personally, I have my clients all sign a retainer, a general retainer. Now, essentially, if I put it into the wording and if I say, hey, you know, if when you sign this, you know, also note you're signing up for the newsletter, maybe you can get away with that. But really, you can't just send people stuff, even if they are your clients. They have to agree to it first. And it's always better to get it in writing. If you can send promotional emails without getting it in writing, but that goes into implied consent. And you really want to follow that up with something in writing just to cover yourself if that commission comes after you, right? Then you're going to need proof that, no, this person said it was okay. Here I have their signature, right?
On Facebook, if they, like I have a private Facebook group, if they agree to come on, that's their consent, right? Or do I have to get it ready too?
So on your Facebook page?
Yeah.
Oh, that's not a promotional email. We're talking about sending an email directly to their private email.
Okay.
Yeah, because on social media, if they don't want to look at what you're posting, they just keep scrolling, right? So that's okay. Also because you're inviting people to like your page, right? They have to like your page first before they see any of that.
Right.
Yeah. All right. Okay, so we're going to cover promotional contests. And then I think we have one more thing after that, and then we'll be all wrapped up. Okay. So I want to touch base really briefly on the 10 biggest key contest law issues. The first one is the purchase requirements and consideration. So in Canada, a common issue that arises is if the sponsor can require a purchase be made as a condition of entry. If you do not want to require a purchase, if you do want to require a purchase be made, it is safer to provide a no purchase required entry option, such as writing and emailing in an essay. This would be to avoid the illegal lottery section of the criminal code. Another way to protect yourself would be to include a skill testing question as a condition of winning the prize. This is because under the criminal code, an illegal lottery is where you win something or you're awarded something just by chance. So if you have a contest that is no purchase necessary, you don't have to do anything to enter, you just sign up your name to be included in the contest. There's no skill testing question. There's nothing to be done. You simply do a random draw and then boom, you win a car. That's an illegal lottery, and there's criminal charges for that. Yes.
Who gets charged?
Who gets charged? Well, the promoter of the contest, not the social media company promoting the contest, although they can be held liable, but the person sponsoring the contest, the sponsor. Probably not, actually. If it's not if it's an illegal lottery. Yeah. So you're gonna find though. I mean, if we have smaller businesses, we're not giving away cars, right? We're giving away little things. So they're not gonna come after you for that. But if you're
Is there a monetary amount? Can I ask that?
not really. well, not
Could they go after you for like a
for anything.
$50 or
Yes.
less thing?
If they really wanted to, sure, but who's
not
gonna,
likely to.
no, no, no. I don't think anybody's that crazy. Yeah.
So does putting a skill testing question requirement in protect you then?
Exactly.
Not an illegal-
Exactly. Yeah. So you can have a no purchase necessary contest. Just include a skill testing question. Make it really easy. Problem solved. There you go. Don't have to worry about it. Yeah. Okay. The second issue would be inadequate disclosure. So preparation of contest materials should include both short and long rules. And this is what I was talking about before. So the short rules are typically just one paragraph, which are included with the advertising that sets out the mandatory statutory disclosure requirements and basic rules of the competition. So when the prize is being awarded, how the prize is being awarded, how you can enter, just a really short summary. The long rules are going to form the actual contract between the sponsor and the winner. So it's going to cover things like eligibility and winner release of liability. This is more important if you've won a week's trip to the Bahamas, because then the sponsor really wants to be protected from liability. The third one is not CASL, so Canada's anti-spam law compliant. So if your contest is collecting emails for marketing campaigns, right? So you're saying, if you'd like to enter this contest, give us your email, and we'll enter you into the contest. Well, if you then use that email for your marketing emails and your promotions, that's in violation because you didn't tell this person that upon entering the contest, you will also be sent the monthly newsletters, right? So there has to be that consent. Number 4 is failure to review draft creative material. So again, this is why you want to have a legal professional review the advertisement itself. This is because you may inadvertently be using someone else's logo, someone else's idea. So it's really good just to have a fresh pair of eyes, review it, to look for any possible copyright, trademark, or false advertising issues. Because maybe you're making the prize sound a little too good, right? So just have an independent person, preferably someone from the Law Society, look it over and make sure there are no issues with that. Number 5, failure to comply with social media platform rules. Again, if you're holding a contest over Facebook, you're going to need to review Facebook's rules in terms of promoting contests. You can have your legal team do that if you'd like to pay them, or you can stay up all night and read it yourself, whichever you prefer, but just make sure you read that over. 6, unauthorized use of third-party intellectual property. So if you're giving away a prize, let's say it's an Apple iPhone, can you use a picture of the phone with their logo in the contest advertisement? Right? Those are things your legal team needs to look into. I don't have the answer for that right now because apparently Apple has very strict rules in regards to that. So if you're looking to give away a prize that's very highly regulated, like the Apple products are, you need to look into that. Number 7 is having no contest rules. So you have to have some sort of rules in order to meet the statutory disclosure requirements of the Competition Act and the regulatory guidelines, and just to plain protect yourself from liability. Because you don't want 10 people coming forward and saying, no, I'm the winner, no, I'm the winner, no, I'm the winner, and then all of a sudden, all 10 of them are suing you for the prize. You don't want that. Number 8, contest rules that do not reflect the contest. So do not create a general contest short and long rule contract. Every short and long rule contract should be written specifically for that contest and that contest only. 9, failure to comply with Quebec or international laws. So thinking about your target audience, if this is a promotion or a contest that is Canada-wide, you're going to be touching Quebec, you're going to be touching other provinces. They may have completely different laws in terms of contests and promotions. So that's another reason to get somebody who's legally trained in this area of law, just to ask them to review your contest to make sure you're not going to run into any issues. 10, technical issues. So if you're running this contest online, make sure to include in your long rules a situation where technical issues may arise and what will happen to the contest and the prize and how the prize is awarded if something were to go wrong. So if you're doing the prize over Facebook, you have to like and post and share in order to enter the contest. What happens if something happens to that link? What if you have a technical issue, right? So you have to kind of include those different scenarios. Okay. Believe this is my last slide. Okay. We're going to be talking about online complaints. And again, this one's going to be a little bit more humorous. So this is an online complaint here, and this is an example, I think, of how they handled it wonderfully. So Philippe here is complaining. He says it's an immediate turnoff if a girl's mobile network is Tesco Mobile. Tesco Mobile answers, are you really in a position to be turning girls away? Okay. So don't think lawsuit, think branding opportunity, right? So of course, there's going to be some situations that do warrant litigation from online harassment and complaints that go so far as to damage a company's brand. But for the most part, you're actually in a position to turn a positive spin on a bad situation. The general public, so what you're concerned about here is you're concerned about the general public seeing this horrible comment, right? The general public also understands that there are some bad people out there and you can't make everyone happy, right? So they understand you're going to get some people that write bad reviews. This is your time to shine. This is your time to show that you're not afraid of a little criticism, that you're intelligent, you're quirky, you have a good sense of humor, and appropriately respond to the comment. I think this one here is like just on the cups of being appropriate, but I really like it because I think they just slide right in there. It's a really close one. Yeah. So, I mean, this person already doesn't like you. Why not have some fun with it? And here, there was another link to a whole slew, it's a website, a whole slew of how these companies responded. There was this one, oh my goodness, there was this one man, absolutely crazy. And he came from a certain background, a certain ethnic and cultural background. And he's just going on. What happened was he ordered a loaf of bread from the grocery store. And he included a picture with it because one of the slices of bread was cut like not straight. It was cut like this and not really a big deal, right? But he posts a picture of it to the bread company. Just this long rant about how can he eat a sandwich now? You can't eat a sandwich with this. He's like, well, of course, I wouldn't be making the sandwich. I'm the man of the house. But my wife, all I hear is this the screaming from the kitchen. And what is she going to do? How is she going to make my sandwich? And I had to show her something shiny just so she'd be quiet. And the house is just in an uproar, all because they didn't slice the bread correctly. And so this company is just like, oh my goodness, they're like, we're so sorry this happened to you. We hope peace has returned to your home, but can you please privately message us so we can get back to you to make this right? And then he responds with, are you making fun of me? And they're like, no, never. So they just, they're like, okay, this guy is crazy. We'll just apologize and moving on. There was another guy on there. He was complaining about, he had purchased a certain type of fish he went to the grocery store to buy a certain type of fish and they didn't have any more in stock. So he posted online, it's something about a fishy situation, and the fish company itself, in their response, you could see they were naming like different fish names in their response, and this thing just went on and on. So then he responded with his comment and it included fish names in all of but anyways, it was just very creative. And I couldn't believe it just kept going and going. And I got tired of reading it and I'm like, I'm done. So unfortunately, this link doesn't work, but. Oh, this was it. Yes. No, this is an example of what not to do. Yes, this was a post that Nicole found for me. This is an older one. and she's complaining online to the burger company. She says, I don't know if you can see that. She says, I've ordered a lot of times in the past and always had great food. My experience tonight was terrible. I ordered a chicken burger and chips and a plain cheeseburger. Waited over an hour. When it arrived, the cheeseburger was missing, even though it was on the receipt. And the driver apologized and said he would be straight back. An hour later, the burger comes loaded with sauce and salads, so soggy bread cakes, safe to say I'll never order again. Long rant. This is their response. Blah, blah, blah. We made a mistake and put it right as soon as we could. We also didn't charge you for your full order. It wasn't an hour late. You people are pathetic. Next time you need to get off your arse and go to a dope burger, as you'll never be served by us again. Okay, obviously this is highly inappropriate. So we want to be creative and not inappropriate. Okay, so this is going to conclude my presentation, but what I want you to take away from tonight is 3 things. Number 1, please be careful of what you post online. Number 2, do your research on the specific rules that's going to apply when you're doing something specific online. And number 3, always have a legal professional review your work, just in case. And that is all. Thank you.
And number 4, cite your sources.
That's right.
So Tiffany, when you say that, oh, sorry.
No, go ahead.
When you say have, ask your legal advisor, whatever, so
Mhm.
you have some type of a program where I can keep you on retainer and I can call you? You know, because I think about Legal Shield where
Yes.
you have a
Yeah.
lawyer accessible.
No, you know what? I'm glad you asked that because it is kind of a gray area. But how I operate is, and I think as licensed paralegals, we have a little bit more leeway in terms of billing. So, like I said, I'm a little bit more of a social worker because how this is going to work is you can come to me with your questions, all your questions. I will answer all your questions, but if you need me to take specific action for you, that's when I start charging. But if you come to me with a question and it's like, no, that's not a problem, I'm not going to charge you for asking a question. Yeah.
Depends how long the answer is, you should be charging me.
Well, that's if you're correct. So if you ask me, I want to throw a promotional contest, this is the prize, this is where I want to do it, what rules apply, and I have to do an entire legal memorandum for you, I am going to charge you for that.
Okay.
If it's a quick answer, if you're worried about something litigation-wise and I can give you a quick answer over the phone, I won't charge you.
Okay.
Yes, but
Okay.
if it's going to take a legal memorandum, I'll let you know. I'll let you know how much I charge,
Okay.
and yeah. Yeah, so never be afraid to ask questions, though.
Cool,
Yeah.
thanks.
Thanks. Well done.
Anybody have any other questions for Tiffany?
I do have a quick one, just
Mhm.
kind of going back to the copyright thing.
Yes.
With trademarks,
Mhm.
can somebody trademark a general term? And if they do go ahead and do that, how do you approach that if say it's a garden center?
Mhm.
You have a garden center, and somebody has trademarked the term garden, like it's an everyday word.
Yeah, I don't think you'd be allowed to trademark words that are used that frequently.
Okay.
Yeah.
And how is that determined?
So I'll give you an example. I can't think of the name of the mattress company itself, but they had the most amazing slogan. They said, "We're great in bed."
Mhm.
I love it. They would obviously have that, sorry, is it a patent or a? They would obviously have that slogan protected, but it would be in relation to their company. So in terms of the word garden, I don't think you're going to get that through the application process, because it is an application process. You have to prove that it's unique to your company and it's not for general use. So if you're thinking of something that's very
If it's an
general.
emerging thing, I guess, and it's
Yeah.
becoming a more general term.
Okay, so I'll take my company for example. My slogan is "Licensed to Win," so that would be specific to my company. But if I were to try and just say my slogan is "Licensed Paralegal," I wouldn't get that past the application process because it's a general term, and lots of people are going to need to use that term to say that they are a licensed paralegal. That is a position, so they're not going to get that past the application process. It has to be something specific to your company. Yeah.
Gotcha.
Okay.